January 13, 2021, Terre Haute, Indiana. At 11 minutes past 1 in the morning, a federal official closes a file bearing the seal of the Department of Justice. The document shows a statistic that many find surprising. Since 1976, only 18 women have received the ultimate sanction in the United States, roughly 1% of all such cases carried out in that period. Public perception often suggests that women receive more lenient treatment in capital cases. The data tells a different story. When the state does choose to pursue the most severe punishment against a woman, the legal record typically reveals crimes judged to be exceptionally cruel or notorious. Today's case involves 7 women whose names entered the smallest and most scrutinized list in American criminal justice. Each conviction followed years of appeals, mitigation hearings, and clemency reviews. Each outcome raises questions about proportionality, mercy, and what the law considers the worst of the worst. Death Penalty Information Center. Database, Statistical Foundation for Modern Capital Punishment Patterns. A clerk in a state attorney general's office opens a spreadsheet. The columns track capital sentences by jurisdiction, method, and gender. Since the Supreme Court reinstated the death penalty in 1976, 1,648 people have received the ultimate sanction in the United States. 18 of them were women. The ratio is stark. Women account for roughly 1 in 92 such cases, despite representing approximately 10% of homicide convictions nationwide. The disparity raises fundamental questions. Prosecutors and juries decide which cases warrant the most severe punishment. Those decisions rest on statutory aggravating factors: murder for financial gain, multiple victims, killing a child, commission during another felony. When courts impose death sentences on women, the facts typically involve multiple aggravators, victim vulnerability, and conduct that prosecutors describe in filings as beyond the pale. Appeal posture means where a case sits in the legal ladder: direct appeal to the state's highest criminal court, state post-conviction review, federal habeas corpus proceedings, and finally, clemency. A discretionary act by a governor or pardon board to commute, pardon, or reprieve a sentence. Every woman who received the ultimate sanction since 1976 passed through all 4 stages before the sentence was carried out. LWOP means life without possibility of parole. In many jurisdictions, prosecutors offer LWOP as an alternative to death. Juries weigh aggravating factors against mitigating evidence: childhood trauma, mental illness, intellectual disability, and choose between the 2 sentences. The 7 cases examined here represent instances where juries, judges, and reviewing courts all concluded that LWOP was insufficient. Mitigation means evidence presented to reduce culpability or sentence. It does not excuse the crime. It asks courts to consider context. Brain injury, severe abuse, trafficking, addiction, and mental health diagnoses all qualify as mitigation. The question in every capital case is whether the mitigation outweighs the aggravation. In these 7 cases, appellate courts and clemency boards found it did not. Public discourse often frames women as less violent, more sympathetic, and therefore less likely to face the harshest punishment. The data confirms that women rarely receive death sentences. But when the state does pursue capital punishment against a woman, the case file usually shows extreme facts: premeditation, financial motive, multiple deaths, or victim helplessness. These are not typical homicides. They are outliers among outliers. If the numbers say women are almost never given death sentences, what has to be true about a case for that final punishment to go through? North Carolina Department of Corrections records, November 2, 1984. First woman sentenced to death carried out post-Gregg. A governor's staff member places a clemency petition on a crowded desk. A red circle marks the scheduled date, November 2, 1984. The petitioner is Margie Velma Barfield, age 52, convicted of first-degree murder in the poisoning death of her boyfriend, Stuart Taylor. Arsenic was found in Taylor's body after his death in February 1978. Investigators later concluded that Barfield had poisoned several other people over a period of years, including her mother, Lily Bullard, and 2 elderly individuals for whom she had worked as a caregiver. Stuart Taylor had been a stable presence in Barfield's life. His family trusted her. Medical examiners initially attributed his death to natural causes. Only after an autopsy revealed lethal levels of arsenic did the investigation expand. Prosecutors believed the motive was financial. Barfield had forged checks on Taylor's account and feared discovery. Evidence suggested a pattern. Her mother had died under similar circumstances years earlier. Insurance proceeds followed each death. North Carolina courts sentenced Barfield to death in 1979. Her case moved through direct appeal to the state Supreme Court, state post-conviction proceedings, and federal habeas review. Each court upheld the conviction and sentence. Barfield's attorneys argued that she suffered from prescription drug addiction and had been a victim of domestic abuse. Mental health experts testified about her psychological state. The trial court considered the evidence and found the aggravating factors, particularly the calculated nature of the poisonings and the vulnerability of the victims, outweighed any mitigation. Clemency means an action by a governor or board to commute, pardon, or reprieve a sentence. Barfield's legal team filed a clemency petition with North Carolina Governor James Hunt. Supporters emphasized her age, her expressions of remorse, and her work counseling other inmates. Victim family members and prosecutors urged the governor to let the sentence stand. On November 1, 1984, Governor Hunt announced his decision: clemency denied. Many observers outside North Carolina assumed the sentence would be blocked at the last minute. The record shows otherwise. Each reviewing court affirmed the conviction. The governor declined to intervene. On November 2, 1984, Velma Barfield's sentence was carried out. She became the first woman to receive the ultimate sanction in the United States since 1962. The outcome marked a turning point. For 22 years, no woman had been subjected to capital punishment in America. Barfield's case demonstrated that gender alone would not prevent the state from carrying out a death sentence. The legal standard remained the same. Aggravating factors must outweigh mitigation. In Barfield's case, courts and the governor found they did. If clemency is supposed to be a fail-safe mechanism, how often does a woman's age, health history, or caregiving role actually influence that final decision? Case number 6, Judy Buenoano, the serial poisoner artifact, Florida Supreme Court opinion, Buenoano v. State, affirming capital murder conviction. A medical examiner in Florida reviews toxicology reports. The body of James Goodyear, a sergeant in the United States Air Force, was exhumed in 1983, 13 years after his death. Laboratory tests revealed high levels of arsenic in his remains. Goodyear had died in September 1971 after a brief illness characterized by symptoms consistent with poisoning. His wife, Judy Buenoano, collected life insurance benefits totaling more than $90,000. The investigation widened. In 1980, Buenoano's boyfriend, Bobby Joe Morris, died in Colorado under circumstances similar to Goodyear's death. In 1983, Buenoano's son, Michael Goodyear, a paraplegic, drowned when a canoe capsized during a fishing trip with his mother. Witnesses described the canoe as stable. Michael was wearing heavy braces that made swimming impossible. Insurance policies on Michael's life named Buenoano as beneficiary. In 1983, Buenoano's fiancé, John Gentry, survived a car bombing. Gentry had been experiencing mysterious illnesses. After the bombing, he became suspicious and contacted authorities. Investigators found that Gentry had high levels of arsenic in his system and that Buenoano had taken out life insurance policies on him. The pattern became clear. Buenoano had systematically targeted men close to her for financial gain, using poison and staged incidents. Buenoano was tried and convicted of the first-degree murder of James Goodyear in 1985. The jury heard evidence of arsenic poisoning, insurance, fraud, and a calculated pattern spanning more than a decade. Prosecutors presented testimony from forensic toxicologists, insurance investigators, and witnesses who described Buenoano's behavior before and after each death. The jury sentenced her to death. Florida courts also convicted her of the attempted murder of John Gentry and the murder of Bobby Joe Morris, though formal charges were never filed in Michael Goodyear's drowning. Buenoano's case moved through direct appeal, state post-conviction review, and federal habeas proceedings. Her attorneys raised claims of evidentiary error and challenged the sufficiency of the forensic evidence. Courts reviewed the toxicology reports, the insurance records, and the testimony from multiple jurisdictions. Each court upheld the conviction and sentence. Clemency petitions were filed and denied. On March 30th, 1998, Judias Buenoano's sentence was carried out at Florida State Prison. She was the first woman to receive capital punishment in Florida since 1948. The victims in Buenoano's case were people who trusted her: a husband, a boyfriend, a disabled son, and a fiancé. Each believed they were building a life with her. The evidence showed she viewed them as financial opportunities. When multiple deaths across state lines all lead back to the same person in the same method, at what point does a pattern of calculated violence remove any question about the appropriate sentence? A homicide detective in Texas receives a tip in August 1983. The caller reports that Betty Lou Beats's fifth husband, Jimmy Don Beats, has been missing for 2 weeks. Beats told friends and family that Jimmy Don had left her. She filed a missing person report. Investigators obtain a search warrant for the property where Beats lived with her husband. In the front yard, beneath a decorative wishing well, they find Jimmy Don Beats's remains. Evidence showed he had been shot twice in the head. The excavation continues. In a storage shed behind the house, buried under concrete, investigators find a second set of remains. Dental records identify them as Doyle Wayne Barker, Beats's fourth husband, who disappeared in 1981. Barker had also been shot. Beats had reported him missing and collected on his life insurance policy. Betty Lou Beats was tried for the capital murder of Jimmy Don Beats in 1985. Prosecutors presented evidence that Beats had shot her husband while he slept, then enlisted the help of her adult son to bury the body. Financial motive was clear. Beats was the beneficiary of Jimmy Don's life insurance policy and his military pension. The state introduced evidence of Doyle Barker's death to establish a pattern. The jury found Beats guilty and sentenced her to death. Beats's case moved through direct appeal, state habeas corpus proceedings, and federal habeas review. Her attorneys argued ineffective assistance of counsel, claiming that trial lawyers had failed to investigate and present extensive mitigation evidence. Records showed that Beats had experienced severe childhood sexual abuse and sustained domestic violence from multiple partners throughout her adult life. Mental health experts later documented depression, post-traumatic stress, and other psychological conditions. Defense counsel argued that this history should have been presented to the jury during the penalty phase. Mitigation omission claims are common in death penalty appeals. Under the legal standard established by the Supreme Court in Strickland v. Washington, a defendant must show that counsel's performance was deficient and that the deficiency prejudiced the outcome. Texas courts reviewed Beats's claims and concluded that even if trial counsel had presented the abuse history, the jury likely would have imposed death given the strength of the aggravating factors. 2 murdered husbands, both buried on her property, both followed by insurance claims. Federal courts agreed. Appeal posture means where a case sits in the appeals ladder: direct appeal, state post-conviction, federal habeas, then clemency. Beats exhausted every level of review. In 2000, her attorneys filed a clemency petition with the Texas Board of Pardons and Paroles. The board voted to deny clemency. Governor George W. Bush declined to intervene. On February 24, 2000, Betty Lou Beats's sentence was carried out at the Huntsville unit in Texas. Jimmy Don Beats had served in the military and worked in construction. His family described him as hard-working and devoted. Doyle Wayne Barker had been a boat dock operator. Both men trusted the woman they married. Both were killed in their own homes. If a jury never hears the full story of a defendant's trauma and abuse, can we say the death sentence that follows is truly informed by all relevant facts? Texas Court of Criminal Appeals. Opinion: Newton v. State, affirming triple capital murder conviction. A police officer responds to a welfare check in Houston on April 7, 1987. The caller, Frances Elaine Newton, reports that she returned home to find her apartment door open and fears something is wrong. Inside, officers discover 3 victims: Newton's husband, Adrian Newton, age 23, her son, Alton, age 7, and her daughter, Farah, age 21 months. All 3 had been fatally shot at close range. The investigation quickly focused on Frances Newton. She had taken out life insurance policies on her husband and children weeks before the murders, totaling nearly $50,000. Witnesses reported that the marriage was troubled and that Newton had been involved with another man. Forensic evidence showed that the murders occurred earlier than Newton claimed she had been away from the apartment. A handgun matching the caliber used in the crime was found in Newton's possession. Gunshot residue testing produced results that investigators said linked Newton to the incident. Newton was tried for capital murder in 1988. The prosecution argued that she had killed her family for insurance money and to free herself from the marriage. The jury heard testimony about the insurance policies, the timeline discrepancies, and the physical evidence. Newton's defense attorneys challenged the forensic evidence and argued that another person could have committed the murders. The jury deliberated and returned a guilty verdict. The sentence was death. Newton's case became the subject of extensive post-conviction litigation. Her appellate attorneys raised claims about the reliability of the gunshot residue testing, the handling of evidence, and the adequacy of her trial representation. They argued that advances in forensic science called into question the conclusions reached at trial. The gun that prosecutors said was the murder weapon was later tested and found not to match the bullets recovered from the victims. Defense lawyers argued that this evidence raised serious questions about the case. Texas courts reviewed the new forensic claims and found them insufficient to overturn the conviction. Judges noted that the gun evidence was only one piece of the prosecution's case. The insurance policies, the timeline, and witness testimony remained intact. Federal courts also denied relief. Newton's attorneys filed multiple clemency petitions. Supporters argued that the forensic discrepancies created reasonable doubt. Prosecutors maintained that the totality of the evidence supported the jury's verdict. On September 14, 2005, the Texas Board of Pardons and Paroles voted to deny clemency. Governor Rick Perry declined to grant a reprieve. Frances Newton's sentence was carried out that evening at the Huntsville unit. She maintained her innocence throughout the legal process. Adrian Newton had worked in construction. 7-year-old Alton was described by teachers as a bright, happy child. 21-month-old Farah had just begun to talk. Their extended family members attended the trial and the clemency hearings, seeking answers and justice. When forensic evidence used at trial is later called into question, but other evidence remains strong, how should courts balance finality against the possibility of error? Texas Board of Pardons and Paroles clemency vote record, February 1, 1998, 18-0 denial. A corrections officer at the Mountain View unit in Texas prepares transfer paperwork. Carla Faye Tucker, age 38, is scheduled to be moved to the Huntsville unit for a scheduled date of February 3, 1998. Tucker was convicted of capital murder in the deaths of Jerry Lynn Dean and Deborah Thornton during a burglary on June 13, 1983. The crime was brutal. Tucker and her boyfriend, Daniel Garrett, broke into Dean's apartment intending to steal motorcycle parts. Dean was asleep. Tucker and Garrett attacked him with a hammer. Deborah Thornton, who was visiting Dean, attempted to hide. Tucker later told police she had used a pickaxe on both victims. Both died at the scene. Tucker and Garrett were arrested days later. Both were convicted of capital murder. Garrett was also sentenced to death, but died in prison of natural causes before his sentence could be carried out. Tucker's trial in 1984 focused on the deliberate and heinous nature of the murders. The jury heard testimony about the violence, the lack of provocation, and Tucker's own statements describing the crimes. The sentence was death. Tucker's case drew international attention not because of doubts about her guilt. She had confessed and never disputed the basic facts, but because of her transformation in prison. Tucker became a devout Christian while on death row. She married a prison chaplain. She participated in substance abuse counseling programs and mentored other inmates. Religious leaders, anti-death penalty activists, and even some victims' family members asked the state to spare her life. Her attorneys presented extensive evidence of her rehabilitation. Television networks interviewed her. Public opinion polls showed that a significant number of Texans, including death penalty supporters, questioned whether her sentence needed to be carried out. Tucker's supporters argued that she was no longer the person who committed the crime 15 years earlier. They pointed to her prison record and statements from correctional staff describing her as a model inmate. Prosecutors and some victim family members countered that the nature of the crime, 2 brutal killings with a pickaxe during a burglary, required the death penalty regardless of subsequent change. Richard Thornton, Deborah Thornton's husband, supported carrying out the sentence. He told reporters that his wife had no opportunity for redemption. Texas law requires that the Board of Pardons and Paroles recommend clemency before the governor can grant it. In February 1998, the board held a hearing and voted 18-0 to deny clemency. Governor George W. Bush reviewed the case and announced he would not intervene. On February 3, 1998, Carla Faye Tucker's sentence was carried out. She was the first woman to receive capital punishment in Texas since the Civil War. Jerry Lynn Dean was 27 years old. Deborah Thornton was 32. Both died violently in Dean's apartment. Their families attended the trial and the clemency hearings. If the justice system claims to value rehabilitation and personal transformation, what should it do when even some victims' relatives say a condemned person has genuinely changed? Arkansas Supreme Court opinion, Riggs v. State, affirming capital murder convictions. A police dispatcher in Sherwood, Arkansas, receives a call at 7:41 in the evening on November 4, 1997. The caller, Christina Riggs, reports that something is wrong with her children. Officers arrive at Riggs's home and find 5-year-old Justin Riggs and 2-year-old Shelby Alexis. Riggs unresponsive. Emergency medical personnel attempt resuscitation. Both children are pronounced deceased at the hospital. The medical examiner's report showed that Justin died from an injection of potassium chloride and manual suffocation. Shelby Alexis died from smothering. Christina Riggs, a licensed practical nurse, had access to potassium chloride through her work. She admitted to investigators that she had caused her children's deaths. She told police she had intended to take her own life afterward, but had failed. Riggs was charged with 2 counts of capital murder. The prosecution presented evidence that the actions were deliberate and premeditated. Riggs had written notes before the deaths indicating her intentions. She had researched methods. The state argued that Riggs's nursing training meant she understood exactly what she was doing. Riggs's defense attorneys presented mitigation evidence. Mental health experts testified that Riggs suffered from severe depression and had experienced suicidal ideation. She was a single mother working long hours as a nurse. Records showed she had sought mental health treatment but had not received adequate care. Defense counsel argued that Riggs had been in a state of extreme emotional disturbance and that she genuinely believed she was relieving her children of future suffering. The jury heard the evidence. Prosecutors argued that depression, no matter how severe, did not justify the calculated killing of 2 defenseless children. The jury found Riggs guilty on both counts and sentenced her to death. Arkansas law allowed for separate sentences. The jury imposed death for Justin's murder and life without parole for Shelby Alexis's murder. The trial court entered a death sentence. Riggs's case moved through direct appeal to the Arkansas Supreme Court. Her attorneys raised claims of mental illness and argued that the mitigation evidence should have resulted in a life sentence. The court reviewed the record and found that the jury had properly weighed aggravation against mitigation. The calculated nature of the actions and the vulnerability of the victims, young children killed by their own mother, constituted overwhelming aggravation. During the appeals process, Christina Riggs made a decision that would define the end of her case. She instructed her attorneys to stop filing appeals. She told the court she wanted to accept her sentence. Arkansas law, like the laws of several other death penalty states, allows capital defendants to waive further appeals if they are found competent to make that decision. The court held a competency hearing and determined that Riggs understood the consequences and was acting voluntarily. On May 2, 2000, Christina Riggs's sentence was carried out at the Cummins Unit in Arkansas. She was the first woman to receive capital punishment in Arkansas since 1945. She did not fight her sentence. In her final statement, she apologized to her children. Justin was 5 years old. He enjoyed playing with toy cars. Shelby Alexis was 2. Family members described both children as happy and affectionate. They trusted their mother completely. When a parent convicted of killing her own children chooses to stop fighting for her life, should the state honor that decision, or does mental illness that led to the crime also undermine the capacity to waive appeals? Comparative case. Summary: reviewing common aggravating factors and mitigation failures. A researcher at a university law school prepares a lecture on capital sentencing. On the board, 5 names appear: Velma Barfield, Judy Buenoano, Betty Lou Beets, Frances Newton, Christina Riggs. Next to each name, the researcher lists aggravating factors established at trial. Barfield: multiple poisoning victims over years, financial motive, betrayal of trust. Buenoano: multiple poisoning victims, insurance fraud, pattern across state lines, attempted murder. Beets, 2 husbands killed and buried, financial motive, abuse of trust. Newton, 3 family members killed, including 2 young children, insurance motive. Riggs, 2 children killed by their mother, calculated method using medical knowledge. State death penalty statutes require juries to find at least one statutory aggravating factor before imposing a death sentence. Common aggravators include murder for financial gain, multiple victims, murder of a child, killing a family member, and murder involving exceptional cruelty. Each of the 5 women discussed so far had cases that involved multiple statutory aggravators. Financial motive appeared in 4 of the 5 cases. Barfield, Buenoano, Beets, and Newton all stood to gain insurance proceeds or other financial benefits from the deaths of their victims. Courts and juries view murder for profit as among the most calculated and cold-blooded forms of homicide. The planning involved in taking out insurance policies, staging deaths, and filing claims demonstrates premeditation over extended periods. Multiple victims appeared in all 5 cases. Barfield poisoned at least 4 people. Buenoano killed or attempted to kill at least 4 people. Beets killed 2 husbands. Newton's case involved her husband and 2 children. Riggs's case involved 2 children. Statutory schemes typically treat multiple murders as especially aggravated because they demonstrate a pattern or willingness to kill repeatedly. Victim vulnerability was present in every case. Barfield's victims were elderly or sick. Buenoano's victims trusted her as a wife or fiancée. Beets's husbands were asleep when killed. Newton's children were 7 years old and 21 months old. Riggs's children were 5 and 2. Courts view the killing of particularly vulnerable victims, children, elderly people, disabled individuals, or people who trust the defendant, as more culpable than killings that occurred during confrontations between equals. Mitigation was presented in each case. Barfield, drug addiction and domestic abuse history. Buenoano, no significant mitigation presented at trial. Beets, severe childhood sexual abuse and domestic violence, not adequately presented to the jury. Newton, claims of innocence and later challenges to forensic evidence. Riggs, severe depression and mental illness. In each case, appellate courts found that the mitigation, even if fully presented, would not have outweighed the aggravating factors. Clemency was sought in all 5 cases. All 5 requests were denied. Clemency rates in death penalty states are extremely low. Texas, which was responsible for Beets, Tucker, and Newton's cases, granted clemency in fewer than 2% of capital cases during the relevant period. Florida had a similarly low rate. North Carolina and Arkansas also rarely granted clemency. LWOP means life without possibility of parole. Mitigation means evidence to reduce culpability or sentence. These terms reappear to assist viewers. The pattern shows that once a case involves multiple statutory aggravators, especially financial motive, multiple victims, and victim vulnerability, the legal system becomes highly resistant to any outcome other than death. Mitigation evidence must be exceptionally strong to overcome that combination. In these 5 cases, courts found it was not. When 5 very different women with different backgrounds and different levels of documented mental health issues all received the same sentence for cases involving financial motive and multiple victims, is the system applying a consistent standard, or is it simply applying the harshest available penalty whenever certain boxes are checked? Case number 1, Aileen Wuornos, highway killings and a fractured life artifact, Florida Supreme Court opinion, Wuornos v. State, affirming multiple death sentences. A clerk at Florida State Prison in Stark updates an inmate file. Aileen Wuornos, age 46, has formally requested to drop her remaining appeals. Florida law requires a competency hearing when a capital defendant seeks to waive further review. The court must determine whether the defendant understands the consequences of the decision and is making it voluntarily. Wuornos has told her attorneys, the press, and the court that she wants the legal process to end. Aileen Wuornos was convicted of first-degree murder in the deaths of 7 men killed between late 1989 and 1990 along Florida highways. The victims were Richard Mallory, David Spears, Charles Carskadden, Peter Seams, Troy Burris, Charles Humphreys, and Walter Gino Antonio. Prosecutors argued that Wuornos lured the men by offering or accepting offers of assistance or companionship, then robbed and shot them. Their remains were found in wooded areas off highways in central and northern Florida. Wuornos claimed self-defense. She told police and testified at trial that the men had assaulted her or attempted to assault her and that she shot them to protect herself. Prosecutors presented evidence that contradicted her account. Forensic analysis showed that several victims had been shot multiple times, some in the back. Their wallets, identification, and vehicles were taken. Wuornos sold some of the victims' belongings and used their credit cards. The evidence pointed to robbery as the motive, not self-defense. Wuornos was tried separately for multiple murders. Juries in multiple counties convicted her of first-degree murder and sentenced her to death between 1992 and 1993. Her attorneys presented mitigation evidence including a history of severe childhood abuse, adolescent sexual exploitation, homelessness, substance abuse, and mental health concerns. Conflicting expert evaluations emerged. Some mental health professionals diagnosed her with borderline personality disorder and post-traumatic stress disorder. Others questioned whether she met criteria for serious mental illness. Wuornos's case moved through direct appeals and post-conviction proceedings. As appeals continued, Wuornos grew increasingly hostile toward her lawyers and the legal process. She gave interviews to journalists claiming that she wanted to die and that continuing appeals were pointless. In 2001, she informed the court she no longer wanted appeals filed on her behalf. Florida law allows capital defendants to volunteer for their sentences if they are competent. The trial court held a hearing to evaluate Wuornos's competency. The judge found that she understood the legal process, comprehended the finality of the sentence, and was acting voluntarily. Her attorneys objected, arguing that her trauma history and mental state made her incapable of rational decision-making. The court disagreed. Governor Jeb Bush signed the final order. Before the scheduled date, Wuornos gave multiple interviews. She made bizarre statements about being tortured by remote control and conspiracy theories involving law enforcement. Her behavior raised questions about her mental state, but the courts had already ruled she was competent. On October 9, 2002, Aileen Wuornos's sentence was carried out at Florida State Prison. The 7 men whose deaths led to Wuornos's convictions were Richard Mallory, age 51, a shop owner; David Spears, age 43, a construction worker; Charles Carskadden, age 40, a part-time rodeo worker; Peter Seams, age 65, a retired merchant seaman; Troy Burris, age 50, a sausage salesman; Charles Humphreys, age 56, a retired Air Force major and child abuse investigator; and Walter Gino Antonio, age 60, a security guard and reserve police officer. Each man had a family. Each was killed while traveling Florida's highways. Wuornos's case became internationally known through media coverage, books, documentaries, and a feature film. Her life story, marked by extreme poverty, childhood trauma, and years of survival, became a focal point for debates about how society responds to women who commit violence. When someone with a documented history of severe trauma and mental health issues seeks to end her own appeals and accept a death sentence, is honoring that wish an act of justice, or a second failure by the system meant to protect her? National death row data showing women whose sentences were commuted or overturned. A policy analyst reviews national death row statistics. As of 2025, approximately 50 women are under sentence of death in the United States. Most have been on death row for more than a decade. Many have pending appeals or clemency petitions. The vast majority will never have their sentences carried out. Some will have their sentences commuted to life without parole. Others will win new trials or resentencing hearings based on constitutional errors. The contrast with the 7 cases profiled here is instructive. Velma Barfield, Judy Buenoano, Betty Lou Beets, Frances Newton, Carla Faye Tucker, Christina Riggs, and Aileen Wuornos all exhausted their appeals and clemency options. In each case, courts found no reversible error. In each case, governors or boards denied mercy. The sentences were carried out. Other women with similar facts have received different outcomes. Sabrina Butler was convicted of capital murder in Mississippi in 1990 for the death of her infant son. She was sentenced to death. On appeal, the Mississippi Supreme Court found the evidence insufficient and ordered a new trial. At retrial in 1995, a jury acquitted Butler. She became the first woman exonerated from death row in the United States. Deborah Milk was convicted of first-degree murder in Arizona in 1990 in the death of her 4-year-old son. She was sentenced to death. In 2013, The Ninth Circuit Court of Appeals overturned her conviction after finding that prosecutors had withheld evidence about a detective's history of misconduct. Charges were dismissed in 2015 after 22 years on death row. Other women have received clemency. In Ohio, Governor Richard Celeste commuted the sentences of 4 women on death row in 1991, citing evidence of severe domestic abuse that had not been adequately considered in their cases. In Oklahoma, no woman's sentence has been commuted in recent decades, despite similar claims of abuse and mitigation. The difference between women whose sentences are carried out and those who receive different outcomes often comes down to jurisdiction, timing, quality of legal representation, and the particular judges or governors involved in the case. Betty Lou Beets and Carla Faye Tucker both had their sentences carried out in Texas, a state with very low clemency rates. Christina Riggs's sentence was carried out in Arkansas after she chose to waive her appeals. Aileen Wuornos had her sentence carried out in Florida after doing the same. Frances Newton's case proceeded in Texas despite later questions about forensic evidence. Mitigation evidence matters, but its effectiveness varies dramatically. Severe childhood abuse, documented mental illness, intellectual disability, and brain injury have saved some women from the ultimate sanction while failing to save others. The legal standard, whether mitigation outweighs aggravation, is applied by different juries, judges, and clemency boards with different results. Geographic disparities are stark. Some states pursue capital punishment frequently, others rarely or never. Some governors grant clemency, others have never done so in retry J continue a capital case. A woman convicted of murder for profit in Texas faces a very different outcome than a woman convicted of the same crime in a state that has abolished the death penalty or rarely uses it. The 7 women profiled here shared common aggravating factors: multiple victims, financial motive, extreme cruelty, or victim vulnerability. But women with identical aggravating factors remain on death row in other states, their cases still pending, their outcomes uncertain. The difference is not always in the facts of the crime, it is in the jurisdiction that prosecuted them, the resources available for their defense, the composition of the jury, the judge assigned to hear post-conviction motions, and the governor in office when clemency is sought. Appeal posture means where a case sits in the appeals ladder: direct appeal, state post-conviction, federal habeas, then clemency. This definition reappears to support viewers who may have joined the episode at different points. If 2 women commit strikingly similar crimes, murder for insurance money, multiple victims, calculated planning, but one receives the ultimate sanction and the other receives life without parole because of differences in state policy or legal representation, what does that disparity say about the consistency and fairness of capital punishment? Legal standards for competency to waive appeals in capital cases. A judge in a Florida courtroom reviews psychiatric evaluations. The hearing concerns a death row inmate's request to drop all remaining appeals. Under state and federal law, a capital defendant has the right to appeal. That right can be waived, but only if the defendant is competent to make the decision. Competency in this context means understanding the legal process, comprehending the finality of the sentence, and acting voluntarily without coercion. 2 of the 7 women examined in this narrative, Christina Riggs and Aileen Wuornos, chose to stop their appeals and accept their death sentences. Both underwent competency hearings, both were found competent, both had their sentences carried out within months of their decisions. Christina Riggs's case raises particularly difficult questions. She killed her 2 young children while suffering from severe depression. Mental health experts testified at trial that she experienced suicidal ideation and believed she was sparing her children from future suffering. After her conviction and death sentence, Riggs told her attorneys to stop filing appeals. She told the court she wanted to die and be with her children. The court found her competent and honored her request. Critics argued that the same mental illness that led Riggs to kill her children also impaired her ability to make a rational decision about waiving appeals. If she was depressed and suicidal when she committed the murders, how could she be considered competent to choose death afterward? Supporters of the court's decision countered that competency is a legal standard, not a clinical one. The question is whether the defendant understands the process and the consequences, not whether a mental health professional believes the decision is wise. Aileen Wuornos' case followed a similar pattern. She initially pursued appeals, then grew frustrated with the process and hostile toward her attorneys. She gave interviews saying she wanted the appeals to end. She made statements suggesting paranoia and delusions. Yet the court found her competent. Her sentence was carried out as scheduled. Nationally, approximately 11% of people whose death sentences have been carried out since 1976 were defendants who waived their appeals, so-called volunteers. The phenomenon is more common than many people realize. Some defendants genuinely prefer death to spending decades in restrictive conditions on death row. Others are influenced by mental illness, despair, or pressure from victims' families. The ethical debate centers on whether the state should participate in what some critics describe as state-assisted self-harm. If a defendant is competent under legal standards but is influenced by depression, trauma, or hopelessness, is it just to carry out the sentence, or does respecting autonomy require honoring the defendant's decision even when that decision is to die? Carla Faye Tucker did not volunteer for her sentence, but she stopped actively fighting it in the final weeks. Her clemency petition was her last effort. When it was denied, she accepted the outcome. Her case differs from Riggs and Warnos because Tucker exhausted her appeals rather than affirmatively waiving them, but the end result, acceptance of the death sentence, raises similar questions about agency, mental health, and the role of the state. LWOP means life without possibility of parole. Clemency means an action by a governor or board to commute, pardon, or reprieve a sentence. These reminders appear periodically to assist all viewers. When a person convicted of murder, especially a woman with documented trauma and mental health issues, says she wants to stop fighting and accept the ultimate sanction, should courts scrutinize that decision more carefully than they scrutinize a decision to continue appeals? Or does equal respect for autonomy mean honoring the choice regardless of its direction? State legislative records showing death penalty abolitions and moratoria since 2000. Legislative aid files paperwork at a state capitol. Over the past 25 years, the use of capital punishment in the United States has declined significantly. In 2000, 98 people had death sentences carried out nationwide. In 2024, only 5 states carried out such sentences, and the total number was 24. Public support for the death penalty, while still substantial, has decreased. Juries are more willing to impose life without parole instead of death. Prosecutors in many jurisdictions seek capital charges less frequently. The 7 women profiled in this narrative had their sentences carried out in 5 jurisdictions: North Carolina, Florida, Texas, Arkansas, and the federal system. The outcomes today might be different. North Carolina has not carried out a death sentence since 2006 due to litigation over protocols. Florida continues to authorize the death penalty, but has faced legal challenges over its sentencing procedures. Texas remains the most active death penalty state, but pursues capital punishment far less frequently than it did in the 1990s. Arkansas conducted multiple such proceedings in 2017, but has not carried out any since. The federal government paused its capital punishment program following a change in presidential administration in 2021. Legal standards have evolved. The Supreme Court's decision in Atkins v. Virginia in 2002 prohibited the use of capital punishment against individuals with intellectual disabilities. The court's decision in Roper v. Simmons in 2005 barred such sentences for offenders who were under 18 at the time of their crimes. More recent cases have addressed issues of jury selection, racial bias, and the adequacy of mitigation investigations. These changes would not have saved most of the 7 women discussed here. None were juveniles at the time of their crimes, and only borderline intellectual disability claims were raised. But the evolving standards reflect growing unease with capital punishment. 23 states have abolished the death penalty entirely. 6 additional states retain it on the books, but have not carried out a sentence in more than a decade. Governors in several states have imposed moratoria, halting proceedings while policy reviews are conducted. The trend is toward narrower use of the death penalty, longer delays between sentencing and any final outcome, and heightened scrutiny of mitigation evidence. Victims' families remain divided. Some believe that the ultimate sanction provides justice and closure. Others find that prolonged appeals cause more pain than resolution. Still others oppose the death penalty on principle, even when their loved ones were murdered. Organizations representing crime victims include members on all sides of the debate. A corrections official opens an archive file. Inside are records for Velma Barfield, November 2, 1984, Judy Buenoano, March 30, 1998, Carla Faye Tucker, February 3, 1998, Christina Riggs, May 2, 2000, Betty Lou Beets, February 24, 2000, Aileen Wuornos, October 9, 2002, Frances Newton, September 14, 2005. Each entry shows the name, the offense, the sentence, the appeals history, the clemency decision, and the final outcome. The page below is blank. Since Frances Newton's case in 2005, no woman had a death sentence carried out in the United States for more than 16 years, until federal authorities resumed their capital punishment program in 2020 and 2021. The gap reflects both the rarity of female death sentences and the declining use of capital punishment generally. The 7 women whose cases were carried out between 1984 and 2005 represent a specific era in American criminal justice. Whether that era will return or whether the trend toward abolition will continue remains an open question. Death penalty. Information Center. Comparative analysis. Patterns in female capital cases. A researcher closes 7 case files. Each woman's story connects to broader questions about how the American legal system applies its most severe sanction. Velma Barfield was the first woman to have a death sentence carried out after the Supreme Court reinstated the death penalty, establishing that gender alone would not prevent the state from pursuing the ultimate punishment. Judy Buenoano's case showed a calculated pattern of poisonings across multiple states and victims spanning more than a decade. Betty Lou Beets raised questions about when a history of abuse constitutes adequate mitigation. Carla Faye Tucker forced a national conversation about whether post-conviction transformation should influence clemency. Christina Riggs illustrated the complexity of mental illness, maternal filicide, and the decision to waive appeals. Frances Newton's case highlighted concerns about forensic evidence and potential wrongful convictions. Aileen Wuornos became the face of debates about trauma, survival, and whether the state should allow mentally ill defendants to volunteer for the ultimate sanction. Patterns emerge across the cases. Financial motive appeared in 5 of the 7. Multiple victims appeared in all 7 cases. Victim vulnerability, elderly people, intimate partners, young children, was present in every case. These aggravating factors, when combined, create a nearly insurmountable barrier to any outcome other than death. Mitigation was presented in every case. Childhood abuse, mental illness, depression, substance abuse, and domestic violence were documented. Courts acknowledged this evidence. In each case, however, judges and juries concluded that the aggravating factors outweighed the mitigation. The legal standard asks whether the mitigation is substantial enough to call for leniency. In these 7 cases, it was not. Clemency was sought in every case where the defendant did not waive appeals. Every clemency petition was denied. The clemency process, theoretically the final safeguard against unjust outcomes, functioned more as a procedural formality than a meaningful opportunity for mercy. Governors and boards reviewed the facts, considered the arguments, and let the sentences stand. Gender played a complex role. Women are far less likely than men to be sentenced to death. When women are sentenced to death, they are less likely to have those sentences carried out. The statistics show that gender provides some protection, but the 7 cases examined here demonstrate that when the state does pursue capital punishment against a woman, it is typically because the case involves extreme aggravating factors that override any benefit gender might otherwise provide. The nature of the crimes matters profoundly. Poisoning multiple people for insurance money, burying 2 husbands after killing them in their sleep, killing 2 people with a pickaxe during a burglary, taking the lives of one's own children through calculated means, shooting a husband and 2 small children for insurance proceeds, killing 7 men along highways. Each crime involved a level of planning, violence, or betrayal that juries found intolerable. Yet, questions remain. Betty Lou Beets' mitigation evidence, severe childhood sexual abuse and domestic violence, was never fully presented to her jury. Should a defendant receive the ultimate sanction when the jury that sentenced her never heard the complete story? Frances Newton's case involved forensic evidence that was later called into question. Should finality outweigh doubts about the reliability of evidence? Christina Riggs and Aileen Wuornos both waived their appeals while showing signs of serious mental illness. Should courts have the power to stop a sentence from being carried out even when the defendant wants it to proceed? The victims in these cases deserve to be remembered. Stuart Taylor, Lily Bullard, James Goodyear, Bobby Joe Morris, Michael Goodyear, Jimmy Don Beats, Doyle Wayne Barker, Adrian Newton, Alton Newton, Farrah Newton, Jerry Lynn Dean, Deborah Thornton, Justin Riggs, Shelby Alexis Riggs, Richard Mallory, David Spears, Charles Carskadden, Peter Seams, Troy Burris, Charles Humphreys, Walter Gino Antonio. Each was a person with family, friends, and a future. Each life was taken by violence. The legal system's response, the ultimate sanction in these 7 cases, cannot restore what was lost. The question that runs through all 7 cases is one of proportionality. No one disputes that these crimes were serious. No one argues that the defendants should have walked free. The question is whether death was the only just response, or whether life without possibility of parole would have served the goals of punishment, public safety, and respect for human dignity equally well. Juries made that determination in each case. They heard the evidence. They weighed aggravation against mitigation. They chose death. Appellate courts reviewed those decisions and found no reversible error. Governors and clemency boards had final opportunities to grant mercy and declined. The process worked as designed. But the fact that the process worked as designed does not answer whether the design itself is just. The 7 cases reveal a system that is heavily weighted toward finality once a death sentence is imposed. Even substantial mitigation, documented abuse, mental illness, brain injury, rarely succeeds in overturning a death sentence. Clemency is almost never granted. Appeals, while lengthy, seldom result in reversals. The threshold for the worst of the worst is defined broadly enough that women with very different life stories, levels of culpability, and degrees of mental impairment all end up in the same place. 18 women have had death sentences carried out in the United States since 1976. 7 of them are profiled here. Each outcome required a series of decisions by prosecutors who sought death, by juries who imposed it, by judges who upheld it, and by governors who declined to stop it. Each decision was made by individuals acting within a legal framework that authorizes capital punishment for certain crimes. The question for society is whether that framework produces outcomes that are just, consistent, and proportionate, or whether the disparities in how cases are charged, tried, appealed, and resolved reveal a system that is arbitrary, inconsistent, and shaped more by geography and politics than by the facts of individual cases. A Department of Corrections official closes the final file. The status line next to each of the 7 names reads, "Sentence carried out." The rows below remain blank. Whether they will ever be filled and under what circumstances depends on decisions yet to be made by prosecutors, juries, judges, and elected officials in the jurisdictions that still authorize the death penalty. The victims are gone. The 7 women are gone. The legal files remain, preserved in archives, available for anyone who wants to understand what happened, why it happened, and whether it should happen again. In a system that claims to value both justice and mercy, the question remains, what does a truly proportionate sentence look like in cases like these?